Welcome to The Legal Truth, the podcast created to provide you general legal information about South Carolina law, lawyers, and the legal process. We will answer many of the questions I've been asked during the past 35 years about South Carolina personal injury claims and workers' compensation claims. My name is Dirk Derrick. I'm the founder of the Derrick Law Firm, and I'm your host.
Please see required ethics disclaimers in show notes.
Welcome to the Legal Truth Podcast. I'm Dirk Derrick, here with co-host Pearl Carey.
Yes.
Pearl, how are you doing today?
I'm doing great. How are you?
Doing fine.
Yay.
I'm doing fine. Pretty Wednesday here in Conway.
Paradise on earth.
Yep. Today we're talking about the truth about how people greatly harm their own personal injury claims. This is a good subject.
Absolutely. Let's get into it.
All right.
So first question, what are the biggest things you've kind of seen over the years where people have kind of, for lack of a better term, messed up their own cases?
Number one, be honest, be honest, be honest.
Right.
There's a couple of different categories where people mess up. There's a category where they do things that are used against them by the insurance adjuster and defense attorneys down the road. And then there's things as far as procedure and process that mess up. Let's look about what insurance adjusters and what defense lawyers will use against people. And it's usually self-inflicted. Number one is be honest.
Right.
Anytime you bring a personal injury claim or any kind of claim, any kind of lawsuit, any kind of where you're in front of 12 people, your credibility is the most important thing.
On the line.
If they can show that you've lied about anything, the jury will wonder whether or not you'll lie about this.
Right.
Especially if you're asking them for money. So the jury doesn't want to be taken by somebody who's not telling the truth. And so it is very, very important to tell the truth in every aspect of the claim.
Right.
It's that starts off with a police officer, starts off with your lawyer. When you go to a doctor, to be honest with your doctor about your prior medical history. Be honest with what you're feeling, what problems you're having. Be honest if you get given a statement to the insurance adjuster, testifying, anything. You got to go in with, I'm going to be honest about everything.
Right.
Tell the truth. And
Just be transparent.
Yep. Because there's a lot of ways to investigate things nowadays.
Yeah.
And a lot of times we get into cases and have depositions and our clients being deposed, and the other side already knows the answer to the questions.
Right.
They're just giving them opportunities not to be honest. And if they can find something that they can impeach them on as far as not being honest, it hurts their case greatly. It can kill the case. So that's the number one thing, be honest.
Absolutely. And do you feel like juries are more likely to kind of point out if someone's lying? Do you feel like there's some like misconceptions that go along with people, speaking to their attorneys and not being truthful? Or
the juries, absolutely.
Yeah.
We do a lot of focus groups. I think I've watched my 410th jury in the last 4 years.
Crazy.
This week. We'll watch number 11 and 12 tonight.
See that?
So, if they smell dishonesty, and it can be somebody not telling the truth about anything, it can be somebody who's malingering. We ask focus group members if they believe that this particular plaintiff who's been injured, are they a whiner or a warrior? Because they sniff out people who exaggerate.
Right.
And who aren't completely honest. It doesn't have to be a straight out lie, but if they start exaggerating, the jury picks up on it.
Or if there's some gray areas or things that just aren't quite adding up, people are going to examine their character and find that out.
Absolutely. But like our mamas and our grandmamas told us when we were little, be honest. That would solve a lot of problems.
Absolutely. So number one, we're saying is honesty, just being transparent with your lawyer from the very beginning of your case is vital. So what would you say is the second most important thing someone needs to think about when they're working with their attorney and examining their case?
Well, the second thing that greatly harmed their cases as it relates to insurance adjusters and defense attorneys would be someone who is not doing what their doctor tells them to do.
Not going to appointments or?
Not going to appointments. It is, if somebody's living their life, just doing their thing, then they get hurt. And all of a sudden they got all these medical appointments. They have to go to physical therapy 3 times a week, or they have to do this, or the doctor wants to put a needle in their back. They want a needle in their back.
Yeah.
Want to do this, want to do that. Everything a claimant does after the date of accident is a piece of evidence.
Okay.
What happens up to the accident going backwards, or up to the incident going backwards, there's nothing we can do about it.
Right.
From the incident forward, everything the plaintiff does is evidence. And everything they do, everything they say from that point forward is evidence.
Right.
That evidence can be good form, bad form, or neutral. If they go to a doctor and the doctor says, to get you well, I want you to do A, B, and C, and they say, don't think so.
Or I don't agree, or right.
They can go get a second opinion, but if they don't do what their doctors tell them to do to try to get them better, juries are not very kind to them on awarding money for any kind of pain or any kind of problem they say they're still having when they haven't done everything possible for themselves.
Absolutely.
That's the biggest thing. Not doing everything for themselves. If they're doing everything for themselves, that carries the day with the jury. If they are not, it's going to harm them. And
right.
I mean, all the focus groups I've watched, that's the biggest thing that harms claims, is when claimants don't do everything they can do to get better.
Right.
Now, people have lives. There's people who can't go to therapy 3 times a day and still make money to support their family. Totally understandable. But as understandable as it is, it does have an effect. If they do not do what the doctors are recommending, what their doctors tell them to do to get better, they better have a dang good excuse. And
if you don't, juries are going to judge you on that.
They don't reduce the value of your claim. It doesn't matter what kind of person you are, they don't reduce the value of your claim.
Absolutely. So have you kind of seen cases where someone explains it and they say, look, like I had family things come up, I had job things come up, and that's why I've been missing these doctor's appointments. Have you seen those, for lack of a better term, excuses kind of work with a jury, or? Well,
yeah, or reasons. I wouldn't call them excuses. There are some excuses, but reasons.
Yeah.
If it's a reason that has validity and has proof behind it, people understand. That. I asked a focus group the other night to raise their hand if they've ever been told to do something by a doctor, and they chose not to do it. And it was 12 for 12. And
interesting.
The same 12 people had just been saying that the plaintiff didn't do everything the doctor told her to do.
Oh, right.
So I thought it was extremely ironic that they were giving the claimant a hard time, but then they all 12 indicated they had done the same thing and thought they had justifiable reason to do so.
Right.
The lesson I got from that is it's different when it's them.
Yeah. Versus the plaintiff.
Versus somebody who's asking for money.
Right.
And so that decreases value for our clients as much or right behind the honesty thing. So honesty and doing everything you can do to get better, including everything the doctor advises you to do. Now, if I have the doctor says, hey, I want to do surgery on you. And you say, well, I'm living with it right now. I'd rather live with it as long as possible.
Yeah.
People understand that.
Okay.
Or if you say, I want to go get a second opinion, people understand that. But it's just when you say, hey, I think you need surgery. I don't want surgery. well, let's put injection. I don't want injections. Okay.
Saying no to
Do
everything.
physical therapy. I don't have time.
Mm.
I mean, if you were on a jury, you would have some of the same thoughts, you know.
Right.
If you put yourself in the juror's position, you know, I'm going to listen to you, but if you're not doing everything you can on your own, why should we compensate? Because we don't know what the
Right.
damages would be if you would do everything that it does.
So there's a bit of murkiness there if people aren't going to their appointments or if they're not being entirely honest with their attorney.
Right.
So I know that you mentioned that going to the doctor is really important when you're told to do so, and then also being honest with your attorney whenever possible. What would you say is the third thing people need to avoid?
I think something that good defense lawyers and insurance adjusters use, and I don't necessarily think it's a fair tactic, but it can be an effective tactic.
Okay.
Is I said everything you say, everything you do after the event becomes a piece of evidence.
Right.
Well, if you're on social media and you're posting things, you're just handing the other side pieces of evidence.
They can find that.
I've just seen pictures on social media where people are smiling with their family. The other side's arguing, well, you weren't hurting them.
Oh my goodness.
So you can, a lot of social media is people putting on their best face. They're not going on social media with a intraction or getting treatment or a heat pad on their back. And they take that to make that appear to be your everyday life to hold down the damages.
So just a little snapshot can have a big impact.
It can have, it has impacts on the jury. I mean, again, the jury does not want to be taken.
Right.
The jury's weighing all the evidence. If plaintiff's testimony and the doctor's testimony that she's got this problem, this causes these limitations, these restrictions, and then there's 150 social media pages with somebody smiling, look happy.
Right.
I mean, what they're saying is, has it really affected her life? So I don't want to say people are messing up their case, but I'm telling you, they use it in such a way to hold down damages.
Right.
Hold down what a jury may understand to be the true effect of an injury going forward.
So social media can kind of be used as a tool to paint a picture of a plaintiff that might not necessarily be true.
That's right. It's a good piece of evidence. I can't imagine a defense lawyer not going through everybody's social media.
Right.
It's actually unethical for a lawyer to tell their client, hey, get rid of that picture. Because it's destroying evidence. Okay. So what would be a wise thing to do if you have the incident? Stay off social media for a while.
Right. Take a break.
Don't be telling the whole world about your incident and everything about it. Just understand there's new sets of eyes looking at what you put on social media to see if there's any way they can use it to harm your case.
So firstly, you said to be completely honest with your attorney. And then the second thing that we've mentioned is the importance of visiting your doctor and going to doctor's appointments when possible. And lastly, we mentioned the importance of staying off social media when possible as well. So what would you say is the fourth thing that people need to avoid in terms of their case?
The fourth thing, as far as the building of a case, is losing contact with your attorney, not working with your attorney.
Okay.
I really like our clients to understand that when we get involved, we're now a team. And all we're trying to do is build a case that is based upon truth and based upon everything we know that's going to add value to their claim.
Okay.
And we need the client's participation in that. We need to know, what they like to do before, who they did it with. Are there any pictures of them doing it?
Yeah.
Who can testify before and after witnesses? We need to be a team. So, and I'm not saying, I think the great majority of our clients, we work well with us.
Check in. Yeah.
In the past, where someone hires an attorney and then disappears
Okay.
for 6 months
Mm.
and then gets back in touch with the attorney. And by that time, things have happened.
Time has passed. Yeah.
Time has passed. It harms the claim if the attorney and the client aren't working together.
Right.
It can be the same thing if the attorney's not contacting the client.
Mm.
We have a policy where we're calling our clients. We got medical liaisons who's staying in touch with them to keep up with what's going on, getting answers from them. Our lawyers call our clients to stay in contact. Our client can call our lawyers whenever they want to.
Right.
Because we want that relationship, because the relationship is important to build a solid case.
So I know that we've discussed 4 things so far that can greatly affect someone's success with their personal injury claim. What would you say is the 5th thing people need to avoid or look out for?
I think that the 5th thing is kind of out of the stuff that's used against us at court
Mm-hmm.
and goes back to things that people harm their cases before attorneys are involved.
Mm.
And it is mainly how they deal with the paperwork they may be receiving from an insurance company
Okay.
and the legal consequences of paperwork. They can be given a HIPAA form. If they sign it, insurance company can look at all their medical records and their whole history.
Right.
That can harm their case. They can be asked to give a recorded statement. That recorded statement, if not given correctly and everything put in context, can be taken out of context when it's in a transcript form and used against them in the future.
Okay.
They can be asked to sign a release on a portion of a settlement or a single policy. And by signing the release, they waive all other recovery
Oh, wow.
that they don't know about. So they can waive policies and coverages by signing with an unrelated insurance company, by signing a release. They can sign what seems to be an innocent property damage release. And it can have consequences that hold down their damages in the future.
Really?
In South Carolina, you can actually collect punitive damages from the property damage coverage on the vehicles.
Okay.
I've seen people settle their property damage claim for an amount they think's fair for their car, sign a full release of the property damage coverage, and they've just prevented themselves from getting that money on their punitive damage claim.
No, yeah.
So people don't know that you can collect punitive damages off your property damage coverage, would sign it, but then they throw in thousands of dollars down the drain.
And they might not even know.
They wouldn't know. And
Right.
so basically it's them not understanding how documents can be used against them, what documents totally close out their case, and what the consequence of these documents on their claim and the damages that they're entitled to.
Oh.
So those are bad conversations.
Right.
Those are conversations when somebody come in and have signed the wrong thing.
They didn't realize.
They didn't realize, and
Yeah.
they've waived claims, and their case is over. And that's not a good conversation.
Absolutely. That sounds really devastating for some people. So I know that you mentioned that sometimes people can, unbeknownst to them, sign away their rights to pursuing further litigation to get punitive damages for their case. What exactly are punitive damages for our first-time listeners?
Punitive damages are damages that are recoverable in South Carolina for the reckless conduct of the defendant.
Okay.
Punitive damages come about when someone is reckless or acting in reckless disregard to the safety of others. It's beyond negligence. It's
Got it.
recklessness. Drunk driving. A bar selling alcohol to a drunk person, they know they're drunk. Punitive damage. Drunk drivers, you get punitive damage. Reckless driving. Distracted driving. People texting and are distracted by their phones, and that causes wrecks. So that adds a lot of value that people don't think about. People,
Right.
they think of medical bills, lost wages, and they're not even thinking about the damages that could be obtained for punitive damages.
Right.
And so the policy office, the coverage, those punitive damages can be collected off an automobile policy from the bodily injury coverage
Okay.
and the property damage coverage. So what we're talking about when people sign their property damage release, they can release our ability to get those punitive damages paid through their property damage.
So if they sign and they're not really looking, or maybe they just don't know, they can sign away their right to being able to sue for punitive damages.
Not the right to sue, but
Okay.
the right to collect it against that policy.
Okay.
Now, if they sign a release, they've waived their right
That's it.
to recover anything for actual or punitive damages.
Okay.
People would not know that by reading the release that
Right.
they're waiving. But that's a way that people harm their cases, by just lack of knowledge.
Right. So that's maybe a good reason for people to talk to a lawyer before they sign anything from their insurance adjuster.
Yeah, I mean, when people hire us, we say, don't sign anything. Don't sign property damage release. Don't sign anything without us looking at it, because there's just so many unforeseen consequences of signing legal documents
Right.
that arise out of these kind of situations.
Absolutely. Well, thank you so much for speaking to me about the importance of being honest with your attorney about everything and not signing anything until you speak to your attorney. So obviously there are a lot of things that people need to consider that could greatly harm their personal injury case. Are there any last things you'd like to mention?
I would just say that if someone has a question about it, they can call and we'll talk to them. It doesn't cost them anything.
Right.
And we can give them some advice as far as whether they should do something or not do something, whether they hire us or not. But we believe in getting lawyers on the phone with people. There's some thought in the industry that you let intake department sign people up and answer. That makes me extremely nervous that lawyers aren't involved early on, giving people advice as soon as they call in.
Right.
So we get people on the phone with one of our lawyers quickly.
Right away.
And doesn't cost anything. They have questions. If you have any questions about whether or not you don't harm your case by doing or signing or saying anything, feel free to call us. We'll give you an answer. Again, that doesn't bind you to hiring us, and it doesn't cost you anything. But we don't like to see people self-inflict themselves into harming themselves. So they can call our attorneys. They can talk to us. Doesn't cost them anything. They don't have to hire us.
Right.
We just hate to see people harm themselves and their families by doing things that they don't understand the consequences of.
Absolutely. Well, thank you so much for speaking to me about the things that people need to avoid in terms of their personal injury case. Thank you to all of our listeners and the people that are watching the video podcast as well for tuning in today. And we look forward to seeing you on the next one.
Thank you for joining us on the Legal Truth Podcast. If you have questions that you would like answered on a future episode, please send them to thelegaltruth@derricklawfirm.com. If you would like to speak to us directly, call us at 843-248-7486. If you find the podcast valuable, please leave us a 5-star review and share the legal truth with your neighbor, friend, or family member who is seeking reliable information about a South Carolina personal injury or workers' compensation claim. Dirk J. Derrick of the Derrick Law Firm Injury Lawyers is responsible for the production of this podcast, located at 901 North Main Street, Conway, South Carolina. Derrick Law Firm Injury Lawyers has included the information on this podcast as a service to the general public. Use of this podcast and any related materials does not in any manner constitute an attorney-client relationship between Derrick Law Firm Injury Lawyers and the user. While the information on this podcast is about legal issues, it is not intended as legal advice and should not be used as a substitute for competent legal advice from a licensed professional attorney in your particular state. Anyone seeking specific legal advice or assistance should retain an attorney. Any prior results mentioned do not guarantee a similar outcome. The content reflects the personal views and opinions of the participants in the podcast and are not intended as endorsements of any views or products. This podcast could contain inaccuracies. The information contained in this podcast does not constitute legal advice and is not guaranteed to be correct, complete, or up to date as laws continue to change. In this podcast, you will hear information about focus groups. Please note that not all of the firm's cases are presented to a focus group. Additionally, when speaking about juries or jurors in relation to a focus group, we are speaking of focus group participants and not actual trial juries or jurors.